This is a screenshot video intro weeks 11 to 12, and for these 2 weeks I put up three different postings, if you will. The first two were about liability insurance, and then the third one, which I have on the screen, is entitled Typical Steps in PI, meaning personal injury case where the client is injured in a vehicular accident. And what I would like to do is walk you through the steps, or the flow chart, I guess it could be called that I have in the posting, and I think we could make some useful points. The first point I don't have on the posting itself, which is how does the injured person see a lawyer? And if you drove around Buffalo and the various expressways, you would see one way, which is you would be seeing billboards with attorneys on them. And certainly since around 1976, many attorneys have advertised their services, particularly in this area, and it's entirely legal. It's an exercise of a First Amendment right of free speech, and very appropriate. So that would be one way. Another way would simply be that the injured person asks around, maybe does some due diligence, and gets a recommendation. Perhaps someone has been previously represented by the lawyer or the law firm and was very pleased with the results, and it's through that method perhaps that the lawyer is contacted by the client. In any event, we have an injured client, and that client sees the attorney, and in the next step or part of the process is I have the lawyer screens. And what is the lawyer screening for? Well, the lawyer is screening these questions. Is there a basis for claiming negligence? And what I'm going to say is that if it's a two-car accident, by way of example, and we have an injured person, there's probably a way for claiming negligence. But certainly the attorney wants to get a very good sense of what happened. There's police reports about the accident that have been filed, and the police reports are oftentimes very helpful in at least giving the attorney a version of what occurred other than what the client is saying. I'm not suggesting the client is misstating anything, but certainly the accident report can corroborate or give additional detail. But that's a question. Is there a basis for claiming negligence? Perhaps the more significant question, is there a basis, the question is asked, is there a basis for claiming serious physical injury? As I've indicated in earlier postings, if we're dealing with a vehicular accident in the state of New York, we know if we're going to be representing the injured party that we're going to have to establish that that person under the insurance law sustained a serious physical injury. Sometimes the attorney simply cannot reach that conclusion, and it may need to await further medical records, and for that matter, further medical treatment. And it may well be that the attorney is going to be awaiting further medical information, and perhaps even awaiting an accident report. But after this initial screening, if the lawyer has a sense that the client is going to have a meritorious claim, certainly the lawyer would want to enter into a retainer agreement with the client. In the civil practice course at the very beginning, we talk about different ways lawyers get compensated. This is one way. Essentially, if it's a personal injury case, it's going to be a contingent fee arrangement, which means that the client, presuming that there's a settlement or a victory at trial, the client is going to receive 2/3 of the recovery, and the lawyer's fee will be the remaining third. And so the lawyer would certainly want the client to sign the retainer agreement, and also have the client sign various authorizations for release of medical and employment records, because down the road the defendant or the insurance company representing the other driver, if a lawsuit hasn't been started yet, is going to be asking for that information or authorizations to obtain that information. The lawyer is also going to, communicate with the individual against whom a claim can be made. So again, let's just say it's a 2-car accident, and the lawyer's going to send the other, and let's assume, by the way, the other vehicle was driven by its owner, so the lawyer is going to send that person a letter advising them that they should share the communications with their liability insurance carrier to protect their rights. At some point, though, the lawyer is going to be in communication with a representative from the carrier. Carrier, again, is the liability insurance company, to see if it's possible to settle the claim. And the lawyer is going to need, and has the right to find out, the policy limits. Of course, this backs us into what we were talking about earlier in the postings about liability insurance. And the policy limits are going to be significant in terms of how the case will be driven as the lawyer proceeds in the representation. And is there a minimum amount of insurance? Is it a case where the other vehicle was a commercial vehicle and there's liability insurance of a couple of $1 million? I'm hardly suggesting that that means that the client is going to get a great recovery, but we certainly would know in that case, a couple $1 million, that it's likely that there's enough money in the policy to satisfy any claim or trial outcome we can get for the client, and we certainly would be willing, or the lawyer, I should say, would be willing. It would make economic good sense for the lawyer and the client to aggressively pursue that case. If the insurance is on the smaller side, then along the way, the attorney and the client are going to have to make some reasonable calculations about how much in terms of disbursements, lining up experts, etc., does it make sense to do. So the policy limits really are so significant. If we move on, if there's no settlement directly with the carrier, and oftentimes there is, I don't think as much today as there was, if I could pick a date, 1978, but you weren't around then anyways. But it's possible that there'll be that settlement. But if not, and the lawyer has the viable claim, then the lawyer is going to commence a lawsuit against the person or persons claimed to be responsible. In the civil practice course, we talk about lawsuits and how they get started and what they entail. What I wanted to point out, start a lawsuit against the persons claimed to be responsible. And even imagining that the vehicular accident that caused the person to see a lawyer because of injuries sustained in the accident is two vehicles, it may well be that the other vehicle was not driven by the owner, but the driver was someone who was operating the vehicle with the owner's consent. And you remember what we've placed in an earlier posting about vicarious liability, but it may be possible in that situation to find two defendants, the person driving and then the person who owned the vehicle, who was vicariously responsible for what we're going to claim the negligent operation of the vehicle. If that driver also had insurance, now we've got two policies to stack up in terms of possible sources of recovery. If it's a three-car collision, so now we're looking at two other vehicles. And of course, if one or both of them were driven not by the owner but by another person with the consent of the owner, you can see where we're starting to get some defendants and other policies in play. What we could also have is that the person injured was not a driver of the vehicle, but is my friend and colleague, Mr. Krasinski, likes to call them a belted passenger, meaning passenger in the vehicle wearing a seatbelt. And why wearing a seatbelt? Because if you're wearing a seatbelt, no one can reduce your recovery under a comparative negligence theory. And that belted passenger can then be in a position to assert a claim against the driver/owner of the vehicle he or she was in and the other vehicle. So there's all kinds of possible ways to get more than one defendant, which is why I have persons. So now we have the lawsuit, and we can ask this question, well, what happens with the lawsuit? One possibility is the lawsuit can be dismissed. And why can it be dismissed? It may be that after a process known as discovery is completed, the defendant's attorney will believe that the defendant is in a position to ask the court to dismiss the claim. That'll be a procedural technique known as a motion for summary judgment. They'll lay out all of the medical evidence and basically make this claim. Under any reasonable view of the medical evidence, you cannot conclude, the argument would go, you cannot conclude that the plaintiff suffered a serious physical injury. And that'll happen sometimes, so it might be dismissed. Oftentimes, after the lawsuit has commenced, it's going to be settled. You can see I have somewhat likely outcome. And anybody who's practiced in this area can tell you the settlements often happen on the eve of trial, can happen during the course of trial, and every so often you'll even see a settlement after the trial because both sides are hinky about what might happen on appeal. But as I noted next, the case can go to trial if it's not settled or not dismissed, and then a verdict is rendered. If it's rendered in favor of the defendant, the case is over, subject to an appeal, and that's known often as a no cause, meaning that the jury found there was no cause to impose liability, and if it could result, and we hope if we're representing the plaintiff, in the verdict in favor of a plaintiff, which would mean there'd be a certain amount of money awarded by the jury. And again, as I've noticed, there's a possibility of appeal unless there's a settlement. Now, I want to talk about damages, but that's deserving of another screenshot video. So I'm going to conclude this, and we'll then do a shorter one about possible damages.